House will come back to order. House will come back to order. Mr. Clerk, will you ring the bell? House will come back to order. The clerk will read the caption to a group of privilege resolutions.
Honoring the life and memories of the 9 victims of the C-130 plane crash near Savannah, Georgia on May 2nd, 2018. Commending and congratulating Erica Spreacher. Commending and congratulating Megan Monroe. Commending and congratulating Dylan Mahoney. Congratulating Alazda Kelly Lowry for her life service. Commending Dr. Charles E. Bax on his outstanding service as a professor at Valdosta State University. Commending Patricia Patty Parker on her outstanding community service. Commending and congratulating Lucy Allen. Commending and congratulating Taylor Allman. Commending and congratulating Carolyn Broley. Commending and congratulating Amanda Leakley. Commending and congratulating Nisha Rajurjan. Commending and congratulating Shreya Ramesh. Commending and honoring Shalandra D. Robertson for exemplary work with crime victims. Commending Deacon Charlie Kimball on the occasion of his 90th birthday. Commending Dr. Kelly McCain, Gage's Administrator of the Year. Commending Zachary Reese, Covenant Christian Academy's 2019 Star Student. Commending the Atlanta Chapter National Epicureans on the grand occasion of his 40th anniversary. Honoring the life and memory of Judge George Carey Nelson III, and for other purposes. That completes the reading of the privilege resolutions.
Is there any objection to adopting the privilege resolutions? The chair hears none, and the resolutions are adopted. Clerk will read the caption to Senate Bill 108.
Senate Bill 108 by Senator Martin of the 9th, Alvarez of the 56th, Miller of the 49, Stones of the 23rd, and others, to be entitled an act to amend Part 2 of Article 6 of Chapter 2, Title 20. The official code of Georgia annotated relating to competencies in core curriculum so as to require courses in computer science in middle school and high school. This bill having referred to the Committee on Education. That committee recommends that this bill do pass by committee substitute.
Chair recognizes Chairman Jaspers to present the bill.
Thank you, Mr. Speaker. I bring before you Senate Bill 108 from Senator Martin. Only a small percentage of our students actually take a computer science course during school. Our economy is increasingly dependent on computer science and our understanding of computer science. It's a subject matter that excites young people, as I saw this summer in Calhoun City Schools and went to a coding class that was being taught there, and the kids were just so excited about it. If you go to our technical schools, you see that computers and computer science is integral to that work. This bill creates a requirement for a computer science course in all middle and high schools. That's not tomorrow. If you read the bill, it's over the next 5 years, but it does a good job getting them there. The bill gives the students, it gives the teachers and the systems time to get a program in place, and it also trains the teachers so they can develop and create a super high quality program. There's a grant program that helps fund it, and good to note that the Senate put $750,000 in their side of the budget to help fund this grant program. The program used the virtual school that we all fund, operated by DOE, to deliver the class where schools don't or can't find a delivery person to be able to do it. It's really important for rural schools because they may not be able to find that. When talking about it, in the committee, we saw that CTAE and our technical college system of Georgia could step in very quickly and help do this, which would be great. And it's one of these programs that's needed right now. We need it a lot. And it's a perfect opportunity for us to move our schools into a higher technology aspect. So I appreciate your favorable consideration on Senator Martin's bill. And Mr. Speaker, I'll yield for questions if there are any.
You have one question.
Yes, sir.
Chair recognizes Representative Jasmine Clark to your left for a question.
Does the gentleman yield?
Yes, ma'am.
So first of all, thank you for this because I do think that it's very important that we start teaching our students more in the direction of STEM. My question though is there anything in this bill that actually provides computers to the students? Since this is going to be mandatory, are we sure that the students are going to have access to the computers? Let's say, for instance, if they have homework or anything for this course.
No, ma'am, I'm not sure what their $750,000 was spent for, but I'm sure within the school, we've adequately spun that now, but I think you're mentioning, are they being able to take them home? That's where I'm going, but I don't know.
All right, thank you.
Yes, ma'am.
You have no further
Mr.
questions.
Speaker, I yield the will and ask your favorable vote.
Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All those in favor of passage of the bill will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines. On the passage of Senate Bill 108, the ayes are 163, the nays are 3. This bill, having received the requisite constitutional majority, is therefore passed. Chair recognizes Chairman Setzler for a motion.
Mr. Speaker, I'd like to make a motion to agree to the Senate substitute to House Bill 481.
Chairman Setzler has moved that this House agree to the Senate substitute to House Bill 481. The clerk will read the caption.
House Bill 481 by Representative Sessler, 35th lot of the 122nd, Taylor to 173rd, and others. Entitled an act to amend Chapter 2 of Title 1, the Official Code of Georgia annotated relating to persons and their rights, to amend Article 5 of Chapter 12 of Title 16 of the Official Code of Georgia relating to abortion.
Chair recognizes Chairman Setzler to explain the Senate substitute to House Bill 481.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, bring before you today the Senate substitute to House Bill 481. This was a measure we debated at some length in the House, and as a result of many of the questions that were asked here, both of House members, of the governor, and others, we addressed in Senate committee a substitute that addressed many of those concerns and questions and makes House Bill 481 an even better bill than what we passed out of the House the first time. We're working off LC version 28935S. That's the actual version that the Senate passed. And What that does is, there were some questions about providing an extra level of protection, a belt and suspenders, if you will, to ensure that accidental deaths from a series of medical procedures from doctors, nurses, physician assistants, and pharmacists could in no way be construed to criminalize the activity of this bill. We provided that affirmative defense. We did the same thing for women seeking emergency abortions. Again, those protections aren't needed specifically by law, but again, an affirmative defense is yet another layer of protection to make sure there could be no misconstruing of any criminal responsibility for those circumstances. Provided a lot of definitions. Again, we fleshed out in detail definitions including abortion, detectable human heartbeat, medically futile, medical emergency. Many of these things existed in law, but to put them in the code section so they're abundantly clear in the operative code section, we added those definitions in. There was a question about law enforcement. We limited the access to records to district attorneys, as is an existing law, and clarified that the records wouldn't just be limited to facility records, but records that were appropriate. In no way could this ever violate HIPAA. I'm sure there will be some questions about that, but we have no ability under our law to do anything that would violate HIPAA privacy protections. This simply allows access to records that are relative to the abortion and be appropriate for DAs to have access to. One thing this bill does, and I would tell you substantively, listening to members from both bodies speak on this question, I am proud to say that the questions were raised about what are we doing for mothers that are in these difficult circumstances. One thing the Senate substitute does, and I'm very proud, and I think this body can be very proud of, is that women who find themselves pregnant can now, under this bill, have access to child support from the father. I say again, we recognize that oftentimes women, as they go through pregnancy, incur costs. In some cases, if they have a difficult pregnancy, there may be time out of work, bed rest, or other direct medical expenses, and we allow that a woman can pursue child support from the father for doing that. We recognize that it's common today that with simple blood tests, we can establish paternity as early as 8 to 10 weeks, and if a woman should choose to pursue child support from the father, it makes sure that we're providing that in this bill. It's something I think we'd be very, very proud of as a General Assembly. We're also very clear in this proposition that human heartbeat is the threshold by which any of these benefits would apply. And I want to just say there were some questions about that earlier on, so we were abundantly clear that all the benefits and any of the restrictions that are applicable here apply at the point of a detectable human heartbeat. We simplify the legislative findings. Many members in this body in the House Health Committee had questions about the legislative findings we had. So taking the feedback from members of both parties in committee, we simplified those. What was formerly 3 pages of legislative findings were simplified to clarify the status of the child in the womb being a person and the constitutional provisions that establish that. But we simplified that and really addressed many of the concerns we got from both parties in committee. We have legislative findings that are solid and candidly more simple. And then lastly, Mr. Speaker, clarified as well that pregnancies, an ectopic pregnancy, or that a miscarried pregnancy where a child died of natural causes, the removing an ectopic pregnancy or a child that died of natural causes could never be construed as being an abortion. So those are cleanup measures, and again, Mr. Speaker, I think they reflect the common sense sentiment of Georgians. And ladies and gentlemen, as I present to you the Senate Substitute House Bill 481, I would like to once again just say our intention, Mr. Speaker, is to balance the interests of the mother and the child. There's been lots of feedback in this discussion about women's concerns, and we've listened to those. And this bill, though, recognizes the fundamental life of the child in the womb is worthy of full legal protection and balances that basic right to life with the very difficult situation women find themselves in pregnancies. And I think this bill is something we can be very proud of that balances those two interests as well as this General Assembly possibly can. With that, Mr. Speaker, I'd be glad to take questions.
Chair recognizes Representative Erica Thomas to your left for a question.
Does the gentleman yield?
Yes, ma'am.
Is it not true that a vote of yes to this bill will put the burden on the state of Georgia to determine paternity of a fetus while the fetus is still in the woman's uterus?
No, that's not true. The burden's not on the state of Georgia. In fact, as I alluded to earlier, current medical technology that's common allows a blood test to be taken. We know that a child as early as 8 to 10 weeks through the DNA that the child's DNA that mixes in with the mother's blood can allow paternity to be established at 8 to 10 weeks gestation age today. So if a woman should choose to have to establish paternity, in many cases, you may know, paternity is not at issue. There's not a dispute about who the father is, but only in those cases where it was in dispute and the woman wanted to establish that for purposes of pursuing child support. Those mechanisms happen with a relatively simple medical test, and that puts no duty on the state of Georgia to do that.
Does the gentleman further yield?
Sure.
So just to clarify, you're saying that the woman would have to pay for the paternity test and not the state of Georgia?
If a paternity was in dispute, and the woman wanted to pursue a child support payment for direct medical expenses associated with her pregnancy from the father, then she could pursue that through the typical means where paternity is established. There's no duty in the state of Georgia that has to be established in any number of circumstances, but that would certainly be a mother's right to do that.
Chair recognizes the minority leader, Leader Trammell, to your left for a question.
Does the gentleman yield?
Yes, sir, I do.
Isn't it true that passage of this bill will subject women who have a miscarriage to the possibility of being investigated by law enforcement, having their health records exposed to the district attorney and law enforcement officials at what would be one of the most difficult, private, devastating times that a woman could ever face?
Well, to the gentleman's question, let me recognize the sensitivity of those situations. So I don't want to be too glib in my answer. I will direct members to look in the bill. The bill does not do those things. I would say, in the spirit of your question, this is a very difficult set of circumstances, and for that reason, legislators, attorneys from our governor's office have worked to make sure that all these circumstances are addressed because of the nature of these kinds of concerns. I mean, I can direct members to the substitute to the point you ask about a miscarriage. If a woman has a miscarriage, removing a miscarried pregnancy, a child that's died in the womb, is written in the definition out of the definition of abortion, and I can point members to the place in the bill where that's addressed. Line 93 of the bill is very clear. In fact, it's not even necessary to determine that because current law establishes it, but out of an abundance of caution, in the Senate substitute, line 93 says, removing a dead unborn child caused by spontaneous abortion is not included in the definition of an abortion. We were very careful to make sure we included that. So there'd be zero criminal responsibility for that. So appreciate the sensitivity of the gentleman of the circumstances. There is no criminal responsibility that's expanded here for anything related to a miscarriage.
Chair recognizes Chairman Beverly to your left for a question.
Does the gentleman yield?
I do.
If I could draw your attention to lines 256 to 259.
Yes, sir.
Thank you. Is it not true that under this, a vote for yes for 481 would subject a physician to civil action of wrongful death or the criminal act of homicide in the first or second degree? It does not establish who has standing to bring about that action. And the only way to determine who the putative father is to test the DNA of a fetus. And this bill does not address that. And in so doing, the Medical Association of Georgia, the Georgia Academy of Family Physicians, the American College of Obstetricians, Gynecologists, have all opposed House Bill 41.
I think I heard, to the chairman and my friend, I think I heard 3 questions in there. I'll try to address them in order. The way this bill operates does nothing to expand the criminal responsibility of physicians. Currently, under current law, Code Section 16-12-140, if a doctor performs an abortion outside of the provisions laid out in law, they're subject to the prosecution under criminal abortion. This changes nothing in that. Changes nothing there. The suggestion that something more severe like murder doesn't exist. Again, we can have a sort of a judiciary committee discussion. Under the principles of lenity, because the way abortion is defined, anything outside of that definition will be prosecuted as a criminal abortion, and that doesn't change our law in any way by virtue of the way this bill operates. So if that's been alleged to you, they've given you bad facts.
Wait, just gentlemen, further yield, just as a follow-up, just for point of clarity. So in the event that there's an abortion and you're trying to establish who has standing to bring about this suit, if there is a question of who the father is, who the putative father is, that this bill does not address that, you would have to go about doing a DNA test on a fetus to determine who the putative father is to establish who has the right to bring about this suit in the code section. And this bill does not do that.
No, sir. It's let me direct you. Let me find the line in the bill that talks about the civil action. Again, let me tell members too. And I know many of you don't live in the world of civil practice. If there's any violation of the law that's committed against a person, they have standing. It's called a tort. If there's a duty that's violated, there's a tort. They have access to a civil action. Under our existing law, women upon whom abortion is performed in violation of the law have a civil action against a physician. The challenge is, as they look at, there have been courts that have construed, well, is it a regulatory interest that the law be followed, or is it a woman's individual interest? Most courts are going to recognize the woman has a direct interest. This bill simply clarifies that if abortion is performed on a woman in violation of the law, that she has standing to bring a civil action. It doesn't change the existing law, but clarifies so there's no dispute that she has standing if the law is broken in performance of an abortion on her.
And just for a point of, just one question, if you just indulge, just one other time, is that when you establish the fact that the father has rights now within this space, the father does have the potential father has the ability to have standing to bring about this, to bring about wrongful death. And so in that case, how do you determine who the father is when a fetus has been aborted? And this bill does not address that.
Well, what this bill does address is it addresses the fact that a mother clearly has standing. And again, I don't want to follow down rabbit trails that don't apply, but I appreciate the gentleman's question, and I think we've been very clear that the woman does have standing, and no one can dispute that, and I think that's appropriate.
Chair recognizes Representative Kendrick to your left for a question.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, ma'am.
Isn't that true that the reason we're bringing this bill before the floor today is because this is an attempt to overturn existing law, Roe v. Wade, which makes abortion illegal, by bringing this issue before the United States Supreme Court?
To the lady's question about Roe versus Wade, I think this bill is written for a number of reasons. I mean, our first interest is we've got living, distinct human beings in the state. They're living inside their mothers that are being lost every day. I mean, and I'm going to answer your question, but I do want to say this as sort of an antecedent to the answer. We recognize the basic rights, the basic humanity of these children are being robbed 27,000 times every year in Georgia. We, as a General Assembly, are voting to recognize, does that child's rights, should they be recognized or should they not be recognized? We recognize that for the history of our country, states can expand rights more expansively than the minimum standard of the federal government requires. So we're more expansively recognized rights of children in the womb. For example, before the passage of the 19th Amendment, many states recognized women's right to vote before it was required of all states. We're more expansively recognizing the right of a child in ways the federal government doesn't mandate that we do, but we as a state, again, per our Constitution, where the paramount duty of government is to protection of life, we're doing that here. And in doing that, to your question about Roe versus Wade, we were actually following the Roe versus Wade opinion. In fact, in the oral arguments of the Roe v. Wade opinion and written in the written opinion itself. It says, if a state ever establishes the personhood of the unborn child, the logic of the Roe case collapses. In fact, the pro-abortion plaintiffs' counsel recognized that in oral argument. It's written in the opinion. So we're following the Roe v. Wade case that says if a state ever establishes the personhood of the child, the pro-abortion protections that get to overwrite the child's right to life collapse. We as a state are doing that. It's the constitutionally appropriate way that the Roe opinion gives us, and that is precisely why we're doing it the right way, because we recognize the right of the child should be more expansively recognized in the state of Georgia.
Does the gentleman further yield?
Yes, ma'am.
Is it not true that on March 7th, on crossover day, immediately upon adjournment, that Governor Kemp in a press conference stated that if HB 481, this bill passed, that he expected that the bill would in fact be litigated in court?
I think there are many cases that are litigated. I think there will be, I predict that if we should pass this bill and be signed into law by the governor, I predict somebody will sue. I think everybody here recognizes someone will sue over this. The question is, have we operated in a constitutionally sound way where we as a state can recognize the life interest of these helpless children? We've taken great lengths to follow the way the Roe opinion lays out, that a state can recognize the life of the child in a way that changes the status and allows states to do this. So I don't doubt someone will litigate this, but I think we can be proud we're doing this in a way that puts us on the most sound possible constitutional footing for our laws to be upheld.
Chair recognizes Representative Alexander to your left for a question.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, ma'am.
Is it not true that a vote of yes for this bill could result in constituents being interrogated by law enforcement to determine if a woman had a medical emergency to allow for abortion to be performed?
Representative Alexander, I appreciate the question. This really hasn't changed since the House version, but I will address it in the substitute. On line 119 and 120 of the bill, it gives the sole discretion to the physician to make the determination if a medical emergency exists. In fact, even though it's written in current law, we reestablished the definition of medical emergency from line 97 to 103 of the bill, so it's crystal clear what a medical emergency can be. But it is the sole discretion of physicians in making that determination in Georgia. As we alluded to in Senate debate, this General Assembly has always given broad discretion to physicians to make determinations. In fact, many people who would be considered the pro-life side would say we've given too much discretion to physicians, but this General Assembly has always given broad discretion to physicians to make these kinds of determinations, so it is the sole discretion of a physician that these conditions exist, because we want to recognize that if there is a medical emergency that could cause the life or irreparable harm to a woman, that in weighing that out, so sometimes abortion does the least harm and is the appropriate response. I would further say to the lady, we also provide, as I alluded to earlier, the affirmative defense that no woman can be exposed criminally as a result of a medical emergency. So we provided extra protection for the woman in particular because we recognize the difficulty of those situations, but no, as a matter of fact, not. The physician has the sole discretion to establish a medical emergency.
Does the gentleman further yield?
Yes, ma'am.
Is it not true that a vote for this bill could criminalize in vitro fertilization and hurt families who want to have a baby?
Yeah, to your question, there's no way that can happen. In fact, if you look at the definition's qualified by in the womb. In vitro fertilization, I know there have been some states before that have looked at trying to create the personhood status for a child in an IVF clinic. This bill does not do that. This is only for children that are in the womb and has nothing to do with IVF clinics. In fact, we specifically and carefully made sure that it could not have that effect in how we drew the bill.
Chair recognizes Representative Bentley to your left for a question.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, ma'am.
Is it not true that I represent 4 very, very rural counties that do not have a OBGYN located in those counties?
If the lady so states.
And is it not further true that women in those counties that I represent that do not have an OBGYN located in their county will have to travel very, very far to discover if they are indeed pregnant and may not find that out to be after 6 weeks?
Well, to the lady's question, I mean, I think I don't want to get into a class about about women's cycles, but as we go there, typically a woman's on a 28, 30-day cycle. If in fact the restriction accrues at 6 to 7 weeks when the heartbeat typically exists, you've got about a 2-week period from when a woman would expect to have her cycle, in which she would generally be able to pursue and have an abortion. I think the issue, the concern here, as we've talked about, as we've tried to weigh this life interest of the child, we recognize life begins at conception and is worthy of protection. In fact, our laws today protect a child from feticide, not at the point of heartbeat, but our existing law in Georgia today, 16-5-80, provides up to life in prison for a person that attacks a woman and kills her child in utero, beginning at conception, not at heartbeat. Because we recognize, even beginning at conception under our existing law, the value of this child. As we try to balance this, though, we looked at, hey, where do we strike the balance between protecting the life of this child and the interest of the mother that you raised? And I think as has been shown earlier, pregnancy tests women are able to take themselves have been rated as being very, very accurate. So it's not true that women don't have any ability to know whether or not they're pregnant before 6 weeks. In certain circumstances, to have a third-party, medically verified pregnancy test taken based on how they schedule and those kinds of things, some of those things could exist, but it's not true that a woman can't know that she's pregnant. And we are trying to weigh these things out in an appropriate way.
So, does the gentleman further yield?
Yes, ma'am.
Well, maybe I need to rephrase it. During the development of this legislation, was there any discussion about rural Georgia and these communities that do not have OBGYN in them, such as in my entire district, all 4 counties, there's no OBGYN in those communities. So I guess my question is, was there any discussion about the rural communities and the fact that we don't have those type of medical services for women to be able to officially find out that they're pregnant past 6 weeks?
Yes, ma'am. If I could direct you to line 172 to 173 of the bill. 173 of the bill provides this affirmative defense that if a woman sought an abortion she reasonably believed that was a result, the only way, I'm sorry, let me read it very clearly. A woman sought an abortion because she reasonably believed that an abortion was the only way to prevent a medical emergency. That affirmative defense, one of the reasons that exists is because if a woman were in a place where she didn't have an immediate access to a doctor, she believed that a medical emergency was ongoing right then, we wanted to provide that defense. If she thought the only way to save her life was to terminate the life of her child, she should have this as an affirmative defense from prosecution. Because we recognize every person doesn't have immediate access, and we wanted to provide this extra belt and suspenders, if you will, to make sure she couldn't be prosecuted for that. So yeah, that was really written directly because of rural Georgia.
And my last question is, the gentleman further yield?
Yes, ma'am.
Is it not true that I was not here on the day of the debate on this legislation previously because I was at the hospital with my husband for the entire week? Therefore, I wanted to be here today to really expound on the need for rural Georgia and the fact there's no OBGYNs in rural Georgia. Is that not true, sir?
That's true. And to the lady's question, you remember the debate perhaps yesterday on the budget. I was asking Chairman England, how many additional positions are we providing in our medical schools for physicians? I believe if the gentleman actually quoted the number of additional OBGYN slots we're providing in our schools. And I'm proud of that. I think it's something we can all be proud of as a General Assembly. And those issues are related directly to that. I think it's something we recognize we want to address across the state.
Thank you.
Thank you.
Chair recognizes Representative Vernon Jones to your left for a question.
Will my good friend from Cobb County yield, please?
Yes, sir, sure will.
Isn't it true, Mr. Representative, that you and I do agree on a lot of the issues?
We do.
Is it not further true that you and I have never experienced what a cycle is, personally?
Personally, correct.
Is it not further true that this really has become a political issue within your own party? where some members don't want to vote for this, and some members are just really torn on this piece of legislation. Is that not true?
I think I would characterize it differently. I think members broadly recognize the rightness of this. I think that the difficulty has come from the vitriol of the other side of this question. And I'm not talking to the members here. I'm talking about in the hallway and around the state. The ugliness that's come against people who are trying to represent and protect the rights of these helpless children. The ugliness of that is unsettling to members. And I think I'm on the record of even having said that. I mean, as a citizen legislature, it's not every day people get in our face and shout things at us. It's not every day we get emails that are just as stark and as attacking as these are. I think that's the sense in which members, perhaps the majority party, have felt sort of an unease about this. But I think the policy of this is a solid policy that I think, honestly, should be a bipartisan issue. I know there are members of both parties in this chamber that recognize this bill is right and worthy of support.
If I could bring the gentleman back home, yes, is it not true within your own party, members in this body have a difficult time voting for this? Even some of them walked on the bill. Is that not true?
Well, again, Representative Jones, I'm not going to speculate on politics. I want to focus on the four corners of a very serious bill. I've indulged you to answer the question about the ugliness that's come at a number of our members that's been very unsettling and created a level of discomfort. But the substance of this bill is solid, and I think it's something that people in both parties can be supportive of, because we balance the interest of women in very difficult circumstances with the basic right to life of a child. Sure. that our laws do not adequately protect. And that's the four corners of this bill. And I would like to, if it pleases the gentleman, I'd like to leave it there if we could.
Okay, since the gentleman would like to leave it there, I just want to ask the gentleman one further question, if the gentleman doesn't mind.
Yes, sir.
Is it not true that if your members or some of your members vote for this bill, and in 2020 your party loses, there's going to be a new Speaker of the House here, maybe Vernon Jones, and if there's a new Speaker, don't underestimate, and if there's a new Speaker, many in your party will lose power. Many of you, all of you will lose your chairmanships. Staff be changed. It will be a complete overhaul. Is it not true, if you all lose based on this bill, that this body is going to change over?
I disagree with the gentleman's premise. I think the Georgians recognize the rightness of this. There's certainly dissent, but this is not a political issue. We're not doing this for political reasons. We're doing this because it's right. The co-sponsor of the bill, the people that support this bill, have said to me, Ed, there may be some blowback from some quarter of Georgians, some ugliness, but we're doing this because it's the right thing. And I and those that supported it before and will support it today are proud to stand on the substance.
Chair recognizes Representative LaRicchia to your right for a question.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, sir.
Is it not true that in addition to what this bill does to help with some financial assistance for the expecting mothers, that last year we passed a measure through this body, the adoption bill, that would also help with financial assistance to expecting mothers that were putting their children up for adoption from the adopting parents?
Yes, to the gentleman's question, yeah, this body, I believe it was the 2017 session, we passed an historic adoption bill. And what the adoption bill did, for those of you who weren't here when we passed it, was to create conditions in which pregnant mothers who are going to be giving their kids up for adoption can receive more adequate compensation during their pregnancy to make it viable to carry the child to term and give them up for adoption.
Gentleman, further yield?
Yes, sir.
Is it not true that the current governor has said many, many times, unlike what one of our colleagues just mentioned, that we put people and lives over politics, and we'll take whatever comes after us to protect life?
I thank the gentleman for that.
Chair recognizes Representative Lott to your right for a question.
Does the gentleman yield?
Yes, ma'am.
Is it not true that I have recently been inundated with phone calls, texts, and emails from my constituents in District 122, Columbia County, Georgia, in full support of this legislation?
Yes, ma'am, I believe that's the case. I've experienced the same thing to the lady, and I will tell you that folks from across the practice of medicine, I've got letters from nurses, people with nursing degrees and masters of public health, obstetricians, doctors from all over the state that said, listen, the associations sort of put these letters out, but we doctors, people in my entire practice, all support this bill. They recognize it's good policy, and that's been the overwhelming sense that I've gotten from my constituents as well.
Does the gentleman yield again?
Yes, ma'am.
Is it not true that just this week I had an opportunity to speak for the first time with a constituent that was in opposition to this legislation? And in our conversation, she was not aware that this bill had any exceptions by her reading in the media or the newspapers. And in our conversation again, and I would ask for you to clarify and make certain that I was correct, that this bill bans abortions of convenience, but does allow for abortions in the case of the mother's life, the child being medically futile, and in the cases of rape and incest. Is that correct, sir?
That's correct.
Thank you for your time, and thank you for this bill, and my community thanks you.
Representative Lott, you are not questioning the veracity of the news media now, are you? Chair recognizes Representative Bonner to your right for a question.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, sir.
Is it not true that the end result of an abortion procedure is the death of an innocent human being?
Unfortunately, that's the case. We recognize in this bill, I think you know that there's some very difficult circumstances that we're trying to balance here. But in 100% of abortions, a living, distinct human being with their own blood type, their own DNA, distinct from the mother, is destroyed. I will tell you that the reality of abortion, as we alluded to earlier, is so grisly and so gruesome, we can't even show it on the board. I mean, anything we do here, we ought to be able to talk about and display. I can't show it on the board in this house because it's so grisly and so otherwise unfathomable. And the answer is yes, every abortion represents the death of an innocent child.
And is it further not true that this bill recognizes the personhood of the unborn child and affirms that the state of Georgia will protect the lives of our children regardless of geography?
It does.
Thank you for the bill.
Chair recognizes Representative Newton to your right for a question.
Thank you, Mr. Speaker. Will the gentleman yield?
Yes, sir.
Isn't it true that there are nearly 30,000 abortions a year in Georgia?
Ones we know about, we recognize there are abortions happening in doctors' offices that go unreported in our state, but of just the ones we know about in clinics, hospitals, and ASCs, it's nearly 30,000.
Will the gentleman further yield?
Yes, sir.
So isn't it also true as a medical doctor that I understand that in 15,000 of those a year, over 40 times a day, when the challenging decision about abortion is being considered, that there's two women involved. There's the woman who's pregnant, maybe with an unwanted pregnancy, but there's also a daughter involved. Isn't that true?
About 50% of the time, as I understand. Yeah.
Will the gentleman further yield?
Yes, sir.
So isn't it true that while this bill will not, if 40 abortions on young women are being done a day, on young daughters, but this bill won't ban all of them. It does allow exceptions that Representative Lott mentioned. It does allow other exceptions up to 6 to 7 weeks. But isn't it true that this bill, at the point that that young woman has a heartbeat in the womb, along with the mother who also has a heartbeat, that this bill will carefully balance the value of the life of that unborn woman along with the life of the mother and try to do the best we can through both adoption, as was mentioned, and other situations?
I think the gentleman knows of which he speaks. As a medical doctor, this bill does exactly that.
Thank you, sir.
You have no further questions.
Mr. Speaker, I appreciate your time, appreciate the serious consideration of this body. It's been a serious discussion both in the House and the Senate, and again, for the reasons we've discussed before, I would urge your favorable support for House Bill 481.
On the gentleman's motion that the House agree to the Senate substitute to House Bill 481, all those in favor will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? The clerk, have all members voted? Have all members now voted? If so, the clerk will lock the machines on the gentleman's motion. The ayes are 92, the nays are 78. This House has agreed to the Senate substitute to House Bill 481. What purpose does the minority leader of the House rise?
To make a motion. Pursuant to Rule 143, I would move reconsideration of the House's action on House Bill 481.
Gentleman has that right, and the time to do that is now. All those in favor of reconsidering the House's action in giving a constitutional majority to House Bill 481 will vote aye. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machines. On the gentleman's motion, the ayes are 79, the nays are 91. This House has chosen not to reconsider its action in giving a constitutional majority to House Bill 481 to the Senate substitute. What purpose does Chairman Darlene Taylor rise?
Parliamentary inquiry.
State your inquiry.
Mr. Speaker, isn't it true that this House has carried resolutions and bills concerning bullying?
It has.
And further, isn't that what the members of this House have been subjected to over this bill? And if it's not right for children or anyone else, it should apply to us as the members of this House. That kind of action is not tolerable. Every person in this House has the right to vote how their heart is. And I think it's despicable the way some people have acted. Is it not true?
I know the lady feels that to be true. The chair will point out the members of the body here in the chamber have been very respectful this afternoon, and I am appreciative of that. Chair recognizes the chairman of the Rules Committee for an announcement.
Rules Committee 341 right now for 15 minutes.
House will be in recess until 3:30.